This is a case about the limitations of the Tariff Act. And essentially what we're trying to figure out is, what did Congress intend in the late 1920s when they passed the Tariff Act? I believe in this radical proposition that words have meaning, and that when Congress chose the word articles, it meant for the word articles to mean something and not just be filler for stuff or other things like that, but rather it was a term selected for a reason. And what the Federal Circuit was doing in this case is trying to get at, what does this word mean? What does the Tariff Act mean? And how broad is the scope of the ITC's jurisdiction? So before I dive into the case, let me give a little bit of a primer on administrative law. My background is in both administrative law and patents, and my experience is, for a lot of people in more on the patent side of things, you may not have had as much exposure to Chevron and to the administrative law doctrines. So the first thing I want to just mention, the ITC is an independent agency charged with administering the Tariff Act. And under its statute, it's required to use formal adjudication for Section 337 determinations. So we have a landmark Supreme Court case, Chevron versus Natural Resource Defense Council, that gives us a two-step test for evaluating such agency interpretations. In step one, we ask ourselves, did Congress speak to the issue at hand, or is the statute ambiguous? If Congress was clear, then we have what's called a step one failure. In that situation, the court follows Congress's clear intent, and it does not defer to the agency's interpretation. However, if the court finds that the statute was in fact ambiguous, it moves to step two, and it asks itself, was the agency's interpretation reasonable? And it's worth mentioning here that step two failures are extremely rare outside the DC Circuit, outside of DC Circuit decisions, DC Circuit following a slightly different version of Chevron. But both of these, both step one and step two failures are at issue in this case. So the bulk of the majority opinion focuses on the step one failure. In other words, they're saying that Congress was clear that articles is limited to what the court describes as material things, what I think of as just tangible property. And the court uses the traditional tools of statutory interpretation to reach this decision, starting with dictionary definitions. Now, Jeff described this as sort of an off-the-handle hypertextualist viewpoint, and if you're not familiar with Chevron cases, you may wonder, why is the court starting with the dictionary? Well, this is the prevailing approach from the Supreme Court. The Supreme Court has had a number of decisions over the years on how Chevron interpretation works. The conservative justices have been very influential in this area, including Justice Scalia. And dictionary definitions are a common starting point for statutory analysis. Indeed, in some of the Supreme Court decisions, Rucker versus HUD comes to mind. The court really says you start with the dictionary to see what the language means. So here, the Federal Circuit did just that. They turned to a variety of dictionaries. And what they noted was several general dictionaries that were contemporaneous with the passage of the Tariff Act. So dictionaries from 1911 through the late 1920s and early 1930s define articles as material things. And they find that the Tariff Commission's own 1924 dictionary also supports a more restrictive reading of the term articles. And finally, they also use specialty dictionaries. They look at Black's Law Dictionary as well, and find there to be support for this idea that articles is referring to something much more limited than everything under the sun. In addition to dictionaries, they also look at canons of construction. A couple of them in particular. So nocitur associus is one of them. A word is known by the company that it keeps. They don't reference it by name, but they talk about how a term should be used consistently throughout the same statute. Not a radical idea. And when they do this, they observe that Section 337I refers to articles being intercepted at the border. Now, the reason this is relevant is that electronic information can't be intercepted at the border. Customs doesn't have that authority. Customs can only seize things that arrive at ports of entry. So that's one of the reasons they say articles can't be as broad as what the ITC says it means. Another thing they do is they look at the fact that from 1930 to 1974, the sole remedy available in the ITC was just exclusion orders. So the ITC didn't get cease and desist authority until 1974, which means until 1974, the ITC had no way of addressing some kind of a violation of 337 where an intangible article was involved. Another way of saying this is for 44 years, there was no way of remedying any type of importation that involved intangible property. So that's odd. How could Congress have intended for articles to be super broad when they gave the ITC no power to deal with this until 74? And in 1974, they gave no indication that they were changing the definition of articles, nor in 1988. So that's also part of the reasoning for the court, that if what Congress wanted was some super broad jurisdiction for the ITC, then surely they would have given it more power than just exclusion orders. Now, there's a number of other arguments that they made as part of their step one analysis. And one that was mentioned earlier that I want to address was cases that were on point. The case that's being alluded to earlier on was Associated Press, a Supreme Court decision involving telegraphs. So this was the one where people on the East Coast were wiring, hot news stories to people on the West Coast, and then the West Coast agencies were copying these newspaper articles. And the reason why I bring it up is it was a case about newspaper articles. It wasn't a case about trade. It didn't involve the Tariff Act. It didn't involve the ITC. It didn't even involve articles in the context of trade. It involved newspaper articles. And as far as I can tell, that case has absolutely no bearing on any of the issues that are in front of us right now, given it was about a different meaning of the word articles. There were some cases involving Article I courts. I think there was a court of international trade decision, but none of these were binding on the federal circuit. So that's the step one analysis. What I also want to mention is the step two analysis in the majority's decision. So it's worth mentioning here that the federal circuit could have stopped after step one, because they found that the statute was clear, so no deference to the ITC, follow Congress's clear intent. But the Federal Circuit did something very unusual in this case, which is they also held that a step two failure had occurred. That even if the statute was ambiguous under step one, that the ITC's interpretation was unreasonable. And as I briefly mentioned earlier, this is extremely unusual. Outside of the Court of Appeals for the District of Columbia, you don't see step two failures. It's considered to be a fairly extreme case that the agency has authority to interpret an ambiguous term, but what they did was so unreasonable, the court shouldn't follow it. So let me talk about why they held that there was a step two failure. The ITC committed a somewhat egregious error, which I was the first one to catch back in December of last year. In the commission opinion, the ITC quotes a Senate report, so a piece of key legislative history from the passage of the Tariff Act, to support its proposition that Congress intended the ITC's powers to be very broad. And they claimed that Congress said, quote, "The provision relating to unfair methods of competition is broad enough to prevent every type and form of unfair practice." So that seems like a very broad statement, every type and form of unfair practice relating to unfair methods of competition. The problem was the ITC was misquoting the Senate report. What the Senate report actually says is the provision relating to unfair methods of competition in the importation of goods is broad enough to prevent every type and form of unfair practice. And this is very relevant because goods is widely understood to be restricted to tangible property. So during oral argument, I basically sent my paper off to the Federal Circuit to all the judges, hoping that someone would see this. And during oral argument, the Federal Circuit called out the agency for misquoting legislative history. There was no indication of a deletion here. And they used that as the basis for the Step 2 failure, saying that the ITC had essentially misconstrued part of the legislative history, and though it was very likely in error, it did make their position look a lot more convincing than it actually was. So we see a couple of different grounds on which they are, in which they are finding the ITC's analysis to be lacking. So in the few minutes I have left, I want to just give a few closing thoughts here. So one is that this case clearly quashes what I view as being a power grab by the ITC. Now, we have a disagreement here. I understand that the ITC commissioners have plenty of work to do. But for those of us who view Section 337 as being this kind of outdated protectionist statute, we view this as a huge victory because 337 to us has a very limited purpose. It was designed to offset the harsh effects of free trade, and it wasn't about protecting patent rights. It wasn't meant to be an ancillary IP statute. It was meant to be something very narrow and very specific. Another closing thought is just that the ITC has been taught a rudimentary, sort of a lesson in rudimentary statutory interpretation. Don't disregard relevant dictionary definitions just because they undercut the view that you would really like to take. Don't rely on non-contemporaneous statutes. They cite to the Driver's Privacy Protection Act, which I believe came out in the 1990s and has absolutely nothing to do with what articles meant in 1929 when the Tariff Act came out. And also don't misquote your legislative history or at least indicate your deletion when you're removing language from it. I think finally what we see here is that Chevron is here to stay for patent decisions. In Dickinson versus Zerko, the Supreme Court told the Federal Circuit that it is obligated to follow the Administrative Procedure Act just like every other court of appeals in the country does, and that it applies to every agency, even those that involve patent law. And here we see Chevron, from the Suprema decision and now here that Chevron is the appropriate framework for these types of cases. Thank you.